Good afternoon and welcome to today's seminar on the OSC compliance review process and effective compliance systems. My name is Tai Shou. Joining me is Daniela Schipani. We will be your presenters for today. We are both accountants in the Compliance and Registrant Regulation branch of the OSC. And as accountants, our primary responsibility is to conduct compliance reviews or examinations of firms and individuals registered with the OSC in order to assess their compliance with Ontario securities law. So before we begin, here is our standard disclaimer for all presentations. On the screen is the agenda we have planned for today. I will cover part 1 of the presentation. I will start by giving an overview of the Compliance and Registrant Regulation branch. Then I will provide a walkthrough of the compliance review process and including examples. And following that, I will go through some tips on what your firm can do to prepare if you are selected. Daniela will cover part 2 of the presentation. She will begin by reviewing the securities law requirement of all firms to have a compliance system, including a discussion on the roles and responsibilities of the UDP and CCO. Then she will discuss in detail each of the key elements that make up an effective compliance system, including the factors that should be considered when determining the most appropriate compliance system for a firm's operation. Daniela will also provide insight on how CRR staff assess the overall adequacy of a firm's compliance system, and we have also included some resources that can help you to enhance your compliance with securities law in part 3 of this presentation. At the end of our presentation, we'll answer any questions you may have. As a reminder, please send in your questions throughout this webinar using the chat function on the screen. So let's get started. So what is the Compliance and Registrant Regulation branch, or CRR? Who are we and what do we do? Well, CRR is a branch of the OSC that is responsible for registering and overseeing firms and individuals that are in the business of trading or advising in securities and commodities, as well as firms that manage investment funds. The purpose of our registration regime is to assess initially and ongoing the proficiency, integrity, and solvency of those registered with us. And some of the ways that we do this includes conducting compliance reviews of registered firms. This is the primary tool we use to assess whether the firm or its individuals have acted in compliance with securities law. And through these compliance reviews, we also gain knowledge and expertise on emerging trends or issues in the industry. And this allows us to develop new or amend existing policies and publish guidance, such as any of the CSA or OSC staff notices, and as, of course, the CRR summary reports. When a firm submits an application to be exempt from a securities legislation, CRR legal staff is involved in reviewing these exemptive relief applications. Just as we are responsible for registering firms and individuals, we also have the authority to recommend refusal of registration or even the suspension of registration. And we also hold several registrant outreach seminars like this one each year on topics affecting you in order to promote strong compliance practices at your firm. These activities are integral to the OSC's vision of being an effective and responsive securities regulator, fostering a culture of integrity and compliance, and instilling investor confidence in the capital market. So here is a visual showing the various teams that make up CRR. So our director is Deborah Faubert, and reporting to her are the Deputy Director of Operations, Deputy Director of Registrant Conduct, Deputy Director of Launchpad and Policy, and the Manager of Data Strategy and Risk. Then below that are the various teams, which are led by their respective managers. So if you look at the titles of the various teams, they're pretty self-explanatory in terms of which segment of the registrant population they oversee. So in terms of who conducts compliance reviews, it will be the 3 operations teams showing in dark blue on the screen. Specifically, the accountants and senior accountants on these teams are involved in every aspect of a compliance review. So as you may have noted, the operations teams are divided based on firm registration category. And we use this approach to segment the registrant population to allow each of the three teams to develop expertise on the business models used and activities engaged by investment fund managers, portfolio managers, and dealers. And for the purpose of this presentation today, the focus will be on the activities performed by these three operations teams. On the screen is a list of all firm registration categories that we directly oversee under the Securities Act and Commodity Futures Act. And of course, we're also responsible to oversee any individuals that are sponsored by these firms. So far, I've answered the question of the who and the why of the compliance review process. Next, I will answer the when, the where, what, how of the compliance review process. So first question is, what information do we look at to select firms for a compliance review? But before I get to answering that question, I want to put the Ontario registrant landscape into context. Currently, there are over 1,000 registered firms and over 60,000 individuals that the OSC oversees directly. This is a lot of market participants. We are unable to review all firms and their registered individuals in a given year. As a result, we have adopted a risk-based approach to selecting firms. This risk-based approach is intended to identify those registrants that are most likely to have material issues or market impact, including any risk of harm to investors. One set of information we use to help us select firms is the information collected through the risk assessment questionnaire, which is a comprehensive questionnaire sent every 2 years to collect information on a number of aspects of a registrant's business. From compliance reviews that Daniela and I have conducted, we have found that some firms have provided incorrect information in the risk assessment questionnaire. Therefore, as we use this information to help with firm selection, it is very important to respond accurately and completely on this questionnaire. We also select firms for review on a random basis to help us evaluate the effectiveness of our risk-based approach so that we can make any adjustments where needed. Other information we use include the annual OSC statement of priorities and our branch CRR priorities, any tips and complaints received, referrals from another regulators, any follow-up reviews, and sweeps on any hot topics. So another question you may have is whether we would review every aspect of your firm's operation. And the answer is it depends. For this, we also apply a risk-based approach to conducting compliance reviews. The extent of the work done in any area will depend on whether we identify it as high risk or not. For example, KYC and client onboarding is a vital function of advising and trading activities, and we typically consider this a high-risk area. Therefore, we will conduct both control testing and substantive testing. On the other hand, if we note that a firm does not engage in very much marketing practices, we will consider this to be a lower risk area and may only perform control testing. On a cycle basis, we also conduct impact reviews where we focus on the largest firms. These are firms that could have a significant impact on the capital market if there were a breakdown in their compliance structure or key operations. Another type of review we do is called targeted or sweep reviews. This is where we focus on a specific topic, such as short-term trading or KYC, KYP, and suitability. Targeted reviews allows us to respond quickly to industry-wide concerns or emerging issues. We can collect information about what market participants are doing and develop guidance. And on an annual basis, we use the CRR summary report to publish our findings and communicate best practices. In the majority of reviews we conduct, we select firms using information we have available. But every so often, we perform for-cost reviews where we are aware of potential compliance issue, for example, received from a complaint or a referral from another regulator. We also conduct a review of new registrants, which is also known as registration as a first compliance review. Here is where we meet and discuss with key persons such as the UDP and CCO to understand about their business plan and to assess their understanding of their securities law obligations. Registration staff is also involved in this process. And the type of the review that we do conduct will guide the information that we request and the duration of the review. We normally conduct compliance reviews on site at a firm's premise, but we may also do so from our own office. So on the screen are the 10 steps involved in a typical compliance review, where the issuance of a compliance report followed by a closing letter is the outcome. So next, I'll go through each of the steps in detail. So once a firm has been selected, the first step of a compliance review process is to gather information to learn about the firm, which I will refer to as Know Your Registrant. So we review a variety of information stored on our server, for example, the risk assessment questionnaire, any information on the National Registration Database, including the list of registered individuals, any submissions to changes in the firm registration or individual registration. We also review your corporate website and do web searches. We will review any prior compliance reports and responses. We may have discussions with CRR registration officers. We will look for information received from other securities regulators, and we will review any complaints, tips, and inquiries stored in our database. So by the time we do come to your office, we have a pretty good idea about your business. So after the Know Your Registrant step 2 is to give your firm a call. So in most cases, we will contact a firm's CCO to notify him or her of our intent to conduct a compliance review. And we typically do this 5 business days in advance of the anticipated meeting date. However, we may give shorter or longer advance notice when appropriate. And during this phone call, we will explain who we are, our intent, and provide a brief overview of the compliance review process, including the date that the review will begin. We will not defer the start date of a review unless there are exceptional circumstances and there are no known risk of harm to clients. So once we have confirmed the start date with you, step 3 is to send a list of books and records that the firm should have ready for us to examine by the opening interview. This books and records request will be based on the firm's registration category or categories, and we will tailor our request based on the scope of our review. So on the screen are some examples of some of the records that we may request from you. So from all firms, we may request your organization chart, any meeting minutes, including CCO's report to the board, and policies and procedures. If your firm is registered as an investment fund manager, we may ask for a list of funds that you manage and any third-party service agreements in place. If your firm is a portfolio manager, we may ask to see a number of client files, including any management agreements signed, and we may ask for your trade blotter for a review period. And if your firm is a dealer, we may select a number of client files and request to see the due diligence conducted on products that were distributed. And for a more detailed list, please refer to the links provided at the end of this presentation. Please note that this is not an exhaustive list, and we may request for additional records as the review progresses. And for secure transfer of electronic records, especially when those with large volume or size, we make available a secure cloud-based file transfer application called Fieldwork. Step 4 is to conduct the opening interview. The date that we do come to your office, we usually have a 2 to 3 hour meeting to obtain a high-level understanding of your firm's business, organization structure, client base, compliance system, for example. And we normally expect the UDP and CCO and any other senior management to attend. Participating in this meeting from CRR are accountants and legal counsel. This meeting helps us to further narrow this focus of our compliance review, and it also provides context for when we start reviewing the requested books and records. On the screen is an example of a Section 20 order, which grants us the authority to visit your office and review the books and records your firm must keep under Section 19 of the Act. This order will be delivered at this meeting. So, after the opening interview, the accountants like Daniela and myself will remain on site to conduct fieldwork or testing, and this is step 5 of the compliance review process. So if there are any issues requiring legal analysis, the legal counsel will get involved. This step usually takes on average 2 to 3 weeks, but may vary depending on the scope of the review, the issues we find, and any other factors. If our dates change requiring us to stay shorter or longer on site, we will keep you informed. Throughout the compliance review process, there is ongoing dialogue between us and you. As we review the records provided, perform walkthroughs of key processes, we may have further questions which we will discuss with the UDP, CCO, or key individuals responsible for those functions. And before we leave your office, and if we have identified any preliminary deficiencies, we will do our best to go through these with you. After we leave your office, what happens during this period? While similar to our expectation on you to maintain evidence to document your compliance with securities law, we also must document and maintain evidence of our testing process and any results to support our conclusion of your firm's compliance with securities law. Depending on factors such as the scope of the review, the size of your firm, whether any novel issues have been identified, and staff's other files, this may take at least 4 weeks after we have left your office. During this time, we will also draft the compliance report based on deficiencies identified. Once we have drafted our compliance report, we will contact the CCO to schedule an exit call or meeting. We aim to have this meeting in person whenever possible. CRR accountants and legal counsel will discuss with the UDP and CCO, and the purpose of this meeting is to go over our findings raised in our report, and this is also an opportunity for you to ask questions and to provide clarifications on any facts provided relating to the deficiencies raised. As our aim is to have ongoing communication throughout the review process, some of our findings should not come as a surprise to you at this point. As mentioned earlier, where we can, we will discuss preliminary findings before we leave your office, and we have found that some registered firms proactively address these preliminary deficiencies while the review is ongoing, so that by the time we have this exit meeting, they have already addressed some of the deficiencies raised. And this is step 6 of the process. Step 7 is to issue the compliance report. After the exit meeting, we will finalize our report and it will be issued within a week. The report is addressed to the UDP because this individual has the ultimate responsibility to ensure compliance at the firm. The CCO is copied on the report because this individual is involved with the day-to-day compliance function. Daniela will speak further on the roles and responsibilities of both the UDP and CCO in part 2 of this presentation. Certain deficiencies in our report may be labeled as significant, and I will go through what we consider to make this determination on the next slide. For every deficiency raised, we will include the specific securities legislation that the firm has not complied with, and where applicable, we will include guidance to assist firms on rectifying these deficiencies. This year, we have also made some changes to the delivery and format of our compliance report. We no longer mail hard copies of the report. Instead, all reports are password protected and emailed to both the UDP and CCO. We also include hyperlinks to securities legislation and guidance, and we have also enhanced the readability of our report by presenting deficiencies in a tabular format with clear headings. We have included templates for firms to use when responding to significant deficiencies. So as mentioned on the previous slide, some deficiencies are labeled as significant. So how do we determine this classification? As with many aspects of our work and the work that you do, professional judgment is used. We would assess the evidence that gave rise to the deficiency and apply criteria such as what is the prevalence of the finding? Was it a one-time noncompliance, or is there a pattern of noncompliance? What is the consequence of the finding to the firm or to clients, for example? Does the finding suggest a process is inadequate or missing? Has the issue been identified in a prior review but was never addressed? So here we look to prior compliance reports, reports received from other regulators, and even reports from a firm's compliance consultant. So if a deficiency was previously raised and not rectified by the firm, this may suggest a lack of commitment by the firm to compliance. We use this classification to signal to you which areas of noncompliance are more serious and where you should be focusing your resources and efforts on today. The next few slides will present excerpts from our revised compliance report. So on the screen is a cover letter that accompanies our compliance report. So as you can see, the report is addressed to the UTP and the CCO is copied. It references Appendix A, which is the response template we want firms to use when responding to significant deficiencies, and it includes hyperlink to the topical guide found on our website for additional information on the compliance process. The table of contents page of the compliance report includes hyperlink to the deficiencies within the body of the compliance report. We also include a glossary section to include all the legislation that are cited in the report. So on the screen is an example of a deficiency point that has been labeled as significant. The example also illustrates the current tabular format. So in this scenario, we found that 15 out of 25 client files where one or more pieces of KYC information was missing. The pieces of information missing are risk tolerance and net worth. As risk tolerance and net worth information is vital to the proper assessment of suitability, this finding is both pervasive, where 60% of client files reviewed had inadequate KYC information, and consequential, as it hinders the proper determination of suitability of investments. Therefore, we have labeled this as significant. So not shown on the screen, but we would typically include in our compliance report are the details from our substantive testing. So for example, we will provide a table listing all 15 client names that had the missing KYC information and the specific KYC information that are missing from their files. So as mentioned earlier, we reference legislation and where applicable guidance. We include hyperlinks to these documents found on our website. So step 8 is for the firm to respond. So once you received our report, you have 30 days to respond with your plan on how you will fix the deficiencies classified as significant. For the deficiencies not labeled as significant, we do not require a written response, but we expect you to address them in a timely manner. As mentioned earlier, one way we select firms is based on whether you have been reviewed in the past. Therefore, when we do conduct a follow-up review, we will make sure that deficiencies that were raised previously have been rectified. As part of our compliance report, we include a template for registered firms to use when responding to us. And when you're putting together your response, you should include sufficient details to explain how the significant deficiency will be rectified. So consider answering the questions of what will be done to address this finding, who will be responsible for executing the plan, and when will the plan be rectified. You can include milestones if the implementation process needs to be conducted over a lengthy period of time or in stages. And include any documentation in your response if available. So continuing with our significant deficiency example illustrated earlier, here is an example of a response that will result in follow-up questions from us. Essentially, the firm states that they will collect the missing KYC information from the 15 clients. The firm expects to complete this by June 30th, 2020. So some questions that pop to mind include who will be doing this? Who is we? How about the other existing clients whose files staff did not review? So in a response, I would expect to be told that it would be the registered representative for the 15 identified clients that would be collecting the missing KYC information, and that each registered representative will review their own client list and identify whether any of their client files have missing information, and to indicate how they will go about collecting such. Another question is, once the information has been collected, will the client's advising or dealing representative reassess the suitability of the client's portfolio or investments? So as suitability assessment is based on KYC information, therefore when new KYC information is collected, a reassessment of suitability needs to be done. If we are in November 2019 right now, why does the firm require 7 months to complete the process to collect missing KYC information from the 15 clients? So if there's a long timeline allocated to an activity, tell us the milestones. For example, you can indicate when you will be collecting the missing KYC information from the 15 clients, when you will determine if any KYC information are missing from other clients, and when you expect to reach out to these clients, and how long you expect for the suitability reassessment to take. Step 9 involves following up with the firm. So if we get a response like the one that we just received, expect to hear from us with more questions. And we expect a response within 2 weeks. Depending on the number of follow-up questions and any internal discussions among CRR staff, this may add several weeks to the compliance review timeline. Therefore, it is very important to include sufficient details in your initial response. If CRR staff is satisfied with your plan to rectify the significant deficiencies, we will close the file by sending out a closing letter. On the screen is an example. It will also be delivered electronically and will be password protected. The receipt of this letter does not necessarily mean that registered firm is in compliance with all aspects of Ontario securities law, given factors such as the scope of our review, the extent of the testing we conducted, and any external factors such as changes in your business model and legislation. If your firm is selected for another compliance review down the road, we will look to see that the plan from a prior review have been implemented to address all deficiencies raised. It is a serious matter whenever we identify firms that have not fixed all deficiencies raised during a prior review. At such time, we may consider using the regulatory tools made available to us through our registrant conduct team or even the enforcement branch. So this step marks the end of a typical compliance review process. Okay. I would also like to take some time to go over the process for a targeted or sweep review. So the sweep process is largely similar to the typical compliance review process that we just went through, but with some notable differences. We do these types of reviews as part of our ongoing commitment and focus on conducting compliance reviews. For a targeted or sweep review, we typically review a larger sample of firms and we focus on a specific topic, such as referral arrangements or short-term trading. We focus our testing around that chosen topic. And this doesn't mean that we will ignore any issues that we become aware of that is outside of our scope. In these cases, we will have discussions with the firm, raise a deficiency if needed, and we may even decide to expand the scope of our review to cover more functional areas of the firm. The review may be conducted on-premise or from our office, and if done from our office, we also refer to these reviews as desk reviews. Sometimes we combine steps 3 and 4 of a typical compliance review process that we just went through, where we would ask for both records as well as questions that we expect a response to. In these cases, we usually give firms 1 month to provide the requested information. Between the time we kick off a sweep to when the first compliance report is issued, this may span over several months. And this is done for good reason. Internally, all staff involved in a sweep meets bi-weekly to discuss issues and share information. Management is also involved in these discussions. We do this not only to share information, but also to benchmark each firm's practice against each other in order to ensure we are raising deficiencies on a consistent basis. In these cases, we will communicate upfront on the timing of the report. So until now, I have gone through the normal course compliance review process, where the outcome is a compliance report followed by a closing letter. However, I would also like to highlight that where a registered firm's deficiencies are particularly concerning, we may take further regulatory actions such as referral to the CRR Registrar on Conduct team or the enforcement branch. And if such recommendation is being made, we will inform you of this. We make these recommendations when we identify situations such as individual servicing clients that have acted without integrity, or when individuals that are registered have not adequately performed their responsibilities, when firms is running into any solvency or cash flow problems, and when we note actions taken by the firm and its registered individuals have caused harm to clients, including any financial loss or unsuitable trades. In these cases, some element of a compliance system has failed to monitor, identify, and escalate these instances of non-compliance. So some of the regulatory remediation tools that may be used in these cases may include the issuance of a warning letter, imposing terms and conditions, or even the suspension of registration. Within CRR, staff makes recommendation for terms and condition or suspension of registration to the director. At this stage, it is a recommendation, but not the final decision. Firms and individuals have the right to the opportunity to be heard proceeding, or OTBH. At the end of the proceeding, it is the director that will decide on the appropriate sanction to remedy the misconduct. And you can find more details about these other outcomes in a prior outreach session, and I have included the link at the end of this presentation. So finally, I want to share with you some tips on how you can prepare for a compliance review so that it runs smoothly. So a good starting point is to conduct a self-assessment of your firm's operation against known deficiencies, concerns, or issues that we have been messaging to the marketplace through various publications. Consider reviewing our annual summary report for dealers, advisors, and investment fund managers. This document is a good tool because it talks about recent findings from our compliance reviews, and we also provide best practices to help you enhance your compliance structure. Through your self-assessment, if you identify areas of deficiency, be open to have those discussions with us and start thinking about how you plan to address them. Another assessment you can do is to review your response to the risk assessment questionnaire and any past compliance reports and responses, because we may ask for clarifications on information found in these documents. We found that reviews run smoothly if the requested books and records are provided at the beginning of the review. And you should also expect any ad hoc requests for documents and meetings as the review progresses. As our review touches on several business functions at your firm, we found that coordinating with one contact person to liaise with for document requests or meetings greatly improved the efficiency of completing our review. And we also found it helpful when CCOs notify other staff at the firm that the firm has been selected for a compliance review so that any adjustments can be made. And finally, have an open dialogue with us. So that's all I wanted to share with you on the compliance review process. One of the best ways that you can prepare for compliance review is by designing and implementing an effective compliance system from the start, which Daniela will discuss in more details.
Thank you, Ty. As Ty mentioned, one of the best ways to prepare for a compliance review is for the firm to have an adequate compliance system in place. However, we continue to have concerns that some registered firms are not establishing an adequate compliance system. This chart shows that the most common deficiency noted by CRR staff during the last fiscal year related to inadequacies in a firm's compliance system. We'd like to point out that the compliance system deficiencies noted in this chart do not all relate to inadequacies in a firm's overall compliance system. This also includes deficiencies noted by CRR staff relating to specific elements of a compliance system, such as weaknesses in a firm's specific internal controls or policies and procedures. There are serious consequences when registered firms have inadequate compliance systems. Not only is this offside securities law, it is also bad for business and may result in complaints, lawsuits, reputational damage, including the loss of existing and future clients, and financial loss, which may also result in the firm having to return money to its clients. An inadequate compliance system also has regulatory implications. In addition to requiring the registered firm to correct its deficiencies, we may also take further regulatory action, which Ty touched upon a little earlier as a possible outcome of our compliance reviews. As a reminder, terms and conditions recommended by CRR staff may include requiring the registered firm to hire an external compliance consultant to correct the deficiencies and to strengthen the firm's compliance system. The terms and conditions may also require the firm to replace its UDP and/or CCO, or they may restrict the firm's business, such as requiring the firm to stop accepting new clients, new investments from existing clients, and/or creating new investment funds. As Ty mentioned, it may also include recommending to the director the suspension of the firm's registration or referring the matter to the enforcement branch. Given the serious consequences of an inadequate compliance system, firms should place a high importance on compliance. Compliance is integral to a firm's day-to-day operations and a cornerstone obligation for a firm's continued fitness for registration. So the second part of today's presentation, we will focus on the key elements of an effective compliance system. We hope to provide you with some factors to consider when developing or improving a firm's compliance system, and hope that by the end of this session, you'll have a better idea of the elements that make up an effective compliance system that is appropriate and tailored to the nature, size, and complexity of a firm's operations. So let's start off by going over what securities law requires. Subsection 32(2) of the Act requires registered firms to establish and maintain systems of control and supervision for controlling its activities and supervising its representatives. Section 11.1 of National Instrument 31103 requires a registered firm to have a system of controls and supervision sufficient to provide reasonable assurance that the firm and its individuals comply with securities law. Section 11.1 also requires the firm to manage its business risks according to prudent business practices. A compliance system should include internal controls and monitoring systems that are reasonably likely to identify noncompliance at an early stage, and a supervisory system that allows the firm to correct noncompliant conduct in a timely manner. So having an effective compliance system does not mean that there will not be any instances of noncompliance. However, the noncompliance is more likely to be detected sooner, addressed more fulsomely, and result in proactive actions to prevent its reoccurrence. Sections 11.2 and 11.3 of National Instrument 31103 also require a registered firm to designate a UDP and a CCO. A firm's UDP and CCO have extremely important compliance roles. They are ultimately responsible for establishing a firm's compliance system in order to ensure that the firm and its representatives comply with securities law. It's critical that individuals designated as UDP and CCO understand and fulfill their required roles and responsibilities under Sections 5.1 and 5.2 of National Instrument 31103, which I will discuss on the next few slides. Firms should consider appointing individuals to act as alternates in order to fulfill regulatory responsibilities in the brief absence of the UDP or CCO, such as during vacations. We will now discuss the responsibilities of the UDP and CCO under Sections 5.1 and 5.2 of National Instrument 31103. Section 5.1 of National Instrument 31103 outlines the responsibilities of the UDP. The UDP must supervise the activities of the firm and individuals acting on its behalf to ensure compliance with securities legislation, and the UDP is also responsible for promoting compliance. While the UDP does not have to be involved in the day-to-day management of a firm's compliance group, the firm's UDP is responsible for overseeing the effectiveness of the firm's compliance system. Section 5.2 of National Instrument 31103 outlines the responsibilities of the CCO. The CCO is an operating officer who is responsible for establishing and maintaining policies and procedures in order to monitor and assess compliance by the firm and individuals acting on its behalf with securities legislation. The CCO must report to the UDP any instance of non-compliance with securities legislation as soon as possible after becoming aware of the matter, including any incident of non-compliance that creates a reasonable risk of harm to a client or to the capital markets, or where there is a pattern of non-compliance. The CCO should report non-compliance to the UDP, even if it has been corrected. So in order to fulfill this obligation, the CCO must have direct access to the UDP and the board, or its equivalent, as needed to report significant issues as they arise. The CCO is also required to submit an annual report to the firm's board of directors that outlines the CCO's assessment of the firm and its individuals' compliance with securities law for the period. It is our expectation that the report prepared by the CCO be fulsome and include a description of the steps that were taken to perform the assessment and the results of the assessment. We also expect it to include a discussion of any material findings and compliance issues, including details on how these issues were addressed. A reminder that the requirement to submit an annual report to the firm's board applies to all registered firms, including one-person firms and firms where the CCO is the sole member of the registered firm's board of directors. We review the CCO's annual report as part of our compliance reviews and use it as a factor when assessing the adequacy of the firm's compliance system and if the CCO is adequately performing his or her responsibilities. When the CCO has not submitted an annual report or submits a report that is not fulsome, this may raise questions about the adequacy of the firm's compliance system and if the CCO is performing his or her responsibilities. Given the importance of the CCO's report to the board, we thought to share some tips on what we feel makes an effective report. So the report should be timely. Preparing a report to the board and submitting it to them a year later is not timely, and the findings may no longer be relevant. Depending on the size of your firm or the number of compliance issues identified, you may want to consider whether the report should be prepared more frequently. For example, we have seen firms with a number of divisions or a number of deficiencies prepare the report quarterly instead of annually. Also, the report should be detailed enough so that the board or anyone else reading the report can understand the importance of the items discussed. We have seen examples of reports that don't have enough detail or glossed over significant issues. And the report should clearly describe the actions that have been taken or will be taken for each identified instance of non-compliance. For more information on the CCO's annual report to the Board of Directors, you can refer to the June 2015 Registrant Outreach session, which has examples of CCO's report to the Board for your reference. While the UDP and CCO have specific and extremely important compliance roles, compliance is not only a responsibility of a specific individual or a compliance department, but rather a firm-wide responsibility and an integral part of a firm's day-to-day operations. We recognize that registered firms range in size from one-person firms with limited and simple product offerings to large firms with multiple and complex product or service offerings. However, maintaining an effective compliance system, as previously mentioned, is a cornerstone obligation for all firms, regardless of size. Our discussion will now focus on the key elements of an effective compliance system. Even where a registered firm is small and has limited and simple product or service offerings, it should consider implementing the elements described in the coming slides in a manner that is tailored and appropriate to the firm's size and business model. All firms, including small firms, are encouraged to meet or exceed industry best practices in complying with regulatory requirements. While policies and procedures are essential, they do not make an acceptable compliance system on their own. The companion policy to Section 11.1 of National Instrument 31-103 provides guidance on the key elements of an effective compliance system, which include internal controls, monitoring and supervision, which consists of day-to-day monitoring and systemic monitoring, a visible commitment to compliance, sufficient resources and training, detailed policies and procedures, and detailed records. I will be speaking to each of these elements in more detail. Internal controls are an important element of a firm's compliance system. Internal controls should mitigate risk and protect firm and client assets, and should be designed to assist firms in monitoring compliance with securities legislation and managing the risks that affect their business, including risks that may relate to, for example, trading, conflicts of interest, business interruption, portfolio management strategies, marketing and sales practices, and the firm's overall financial viability. A firm's internal controls can also allow a firm to take a proactive approach to compliance. For example, including compliance personnel when new business lines are being considered or new products are being developed, can assist the firm in identifying regulatory considerations and prevent potential breaches of securities legislation that may not have otherwise been considered by business units. During our compliance reviews, we have noted missing or inadequate controls in areas such as personal trading, expenses charged to investment funds, and the collection of KYC information for determining the suitability of investments. In our most recently published CRR Annual Summary Report, we do have some examples where we found inadequacies in a firm's internal controls. For example, during our focused desk review on sales practices under Part 5 of National Instrument 81-105, we noted that investment fund managers did not always have adequate internal controls to monitor the provision of non-monetary benefits to participating dealers and dealing representatives. Some examples of inadequate internal controls that we identified included inadequate documentation or tracking of items and activities provided to dealing representatives, and failure by the firm to identify breaches and reoccurrence of breaches related to sales compliance guidelines through internal controls. In addition, in our report, we continue to see registered firms allowing prohibited inter-fund trades to occur between investment funds that are not reporting issuers, that are both managed and advised by the registered firm. Pre-trade controls through, for example, the use of an automated compliance system would serve as an effective internal control in order to identify and prevent these inter-fund trades from occurring in the first place. Another element of an effective compliance system is day-to-day monitoring and supervision. An effective monitoring and supervision system includes monitoring to identify specific cases of noncompliance or internal control weaknesses that may lead to noncompliance, referring the noncompliance or internal control weakness to management, and taking supervisory action to correct the noncompliance or internal control weakness identified. A firm's management is responsible for the supervisory element of correcting noncompliance or internal control weaknesses. At a firm's discretion, its CCO may be given supervisory authority, but this is not a necessary component of the CCO's role. Firms can also use a risk-based approach to monitoring, such as reviewing an appropriate sample of transactions based on high-risk areas or areas where there have been issues in the past. Day-to-day monitoring can include performing regular testing for compliance, such as a periodic review of a sample of client files for each advising representative, documenting what was found, and then speaking to the representative with any issues identified so that they understand the findings and can learn from it. We have found large firms frequently use an automated compliance system to monitor and manage compliance for their trading and portfolio management practices. The use of an automated compliance system can play an integral part in a registered firm maintaining an effective compliance system. Compliance rules are programmed to the trading or portfolio management system, which will then automatically, for example, reject a proposed trade in a security that isn't permitted, or it will identify when a client's portfolio is offside their asset allocation targets. Firms place reliance on the rules programmed to the system in order to reduce the need for individuals to manually check for compliance. This should not completely eliminate the monitoring performed by qualified individuals. For example, any exceptions identified by the automated compliance system should be investigated and addressed by qualified personnel. So from our most recent CRR annual summary report, during a desk review we conducted to assess how investment fund managers were monitoring short-term trading and excessive trading by unit holders of their investment funds, we found that overall the firms that were reviewed were adequately monitoring for short-term trading activity and had adequately documented their policies and procedures. On the other hand, we noted that some mutual funds that are reporting issuers did not always comply with the concentration restriction in illiquid assets outlined in Section 2.4 of National Instrument 81-102. Firms should have an adequate process to monitor compliance with concentration restrictions for illiquid assets, including taking appropriate corrective action in a timely manner for any breaches identified. In addition to day-to-day monitoring, another element of an effective compliance system is overall systemic monitoring. Systemic monitoring requires senior management to assess on a regular basis the overall adequacy of a firm's compliance system, including correcting non-compliance in a timely manner. Systemic monitoring requires a firm to assess whether the firm's day-to-day supervision is reasonably effective in identifying and promptly correcting cases of non-compliance and internal control weaknesses, whether policies and procedures are enforced and kept up to date, and whether everyone at the firm understands and complies with the policies and procedures and with securities legislation. Firms may consider performing periodic self-assessments and take actions to improve their internal controls, monitoring, supervision, and policies and procedures when necessary. The next element of an effective compliance system is a visible commitment to compliance. In order for a compliance system to be effective, there needs to be a strong culture of compliance and an organizational commitment to compliance. Senior management and the board of directors must lead by example and make continued efforts to demonstrate their commitment to high ethical standards. Compliance has to permeate through the entire company at all levels and be ingrained in the day-to-day operations of the firm. It is important for senior management to empower and adequately resource those responsible for compliance and to provide the CCO with appropriate access to senior management and the board of directors in order to discuss any compliance matters as they arise. As previously mentioned, we review the CCO's report to the board during our compliance reviews. A detailed report to the board by the CCO demonstrates a visible commitment by the CCO to the firm's compliance. It's also important that the UDP is visible and present. For example, a UDP that is involved in the compliance reviews conducted by regulators shows a commitment to compliance. The firm should also have sufficient resources to operate an effective compliance system. Common indicators of an inadequate compliance system may stem from a CCO not adequately performing his or her responsibilities. Areas of concern include instances where CCOs have limited involvement in the compliance function, give it inadequate attention, or don't focus on important regulatory obligations. Now, this may be due to an inadequate resource for oversight, supervision, and monitoring, or due to the CCO inappropriately balancing competing job responsibilities. During our compliance reviews, we have seen instances where there was a shortage of compliance resources, resulting in certain monitoring activities not being adequately performed or not being performed in a timely manner. We have also seen situations where business units and staff did not have an adequate understanding of their role and responsibilities, including an understanding of the securities law applicable to their work. Inadequate knowledge of compliance personnel may expose the firm to increased risk as violations may go undetected or inadequate actions may be taken that do not appropriately address the non-compliance or internal control weakness. Firms should provide regular training to its employees so that everyone at the firm understands the standards of conduct and their role and responsibilities. It is also important that employees are provided with ongoing communication, resources, and training on changes in regulatory requirements or changes in the firm's policies and procedures in order to stay current. From our most recent CRR annual summary report, we noted that investment fund managers had not always updated their prime brokerage agreements to meet the requirements of the new custody rules that came into force June 4, 2018. It's imperative for firms and CCOs to stay current on regulatory topics. The companion policy to Section 11.1 of National Instrument 31103 states that detailed policies and procedures should identify controls to be used to comply with laws and manage risk, set out standards for conduct and a system for monitoring and enforcing standards, outline who is expected to do what, when, and how, be readily accessible, be updated when business or laws change, and consider the firm's general duty to deal fairly, honestly, and in good faith with clients. Policies and procedures are a vital tool for firms to establish their systems of control and supervision. While there is no prescribed form or standard, we expect all firms to have written policies and procedures. The policies and procedures should be tailored and appropriate to the firm's size, activities, and risks. Many smaller or new firms engage in a compliance consultant or external legal counsel to help them draft their written policies and procedures manual. This can be a good practice as long as they are tailored to your firm's business and operations. We'd like to also point out the distinction between a policy and a procedure. A policy describes the firm's rule or principles to be adhered to. For example, all personal trades must not take priority over client orders. Meanwhile, the procedures outline who is responsible for the process and indicate the steps to follow to achieve the policy. So for example, the CCO must pre-approve all employee personal trades, and trades in the same security as clients can only take place after the blackout period expires. Essentially, the procedures implement policy. During our reviews, we often note instances where firms do not have an adequate written policies and procedures manual. A good policies and procedures manual is tailored to the firm's business operations and covers all of the firm's registration categories and key functions in sufficient detail. It is regularly updated to reflect changes in the firm's business and regulatory changes. And it outlines the process for escalating identified non-compliance to the CCO. Providing training to employees on the firm's policies and procedures will assist employees in understanding what is required, including an understanding of how to incorporate the policies and procedures into their day-to-day operations. An effective practice may also include requiring employees to certify annually that they have read or reread and understand the policies and procedures. So having a good written policies and procedures manual does not necessarily mean that the firm will not have any significant deficiencies. The key is for employees to understand and follow the firm's policies and procedures. In the resource section of today's presentation, we have included examples of topics and subtopics that may be included in a firm's written policies and procedures manual. We have broken down the topics by registration category. As a reminder, this does not represent an all-inclusive list. A firm must assess if there are any additional areas that are not covered in the example, but applicable to the firm's operations. Firms should keep records of activities conducted to identify compliance deficiencies and the actions taken to correct them. Doing so will establish to us and your senior management and board that you have taken reasonable steps to ensure compliance. In addition, subsection 11.52 of National Instrument 31103 requires firms to maintain records to demonstrate its compliance with internal controls, with its policies and procedures, and to document compliance and supervision actions taken by the firm. In our review of small firms, staff have found that the firms often did not always maintain internal books and records to evidence compliance with securities legislation and with the firm's own policies and procedures. It is particularly important to have adequate documentation in place to demonstrate compliance, given that segregation of duties may be difficult or impossible at small firms due to resource constraints. From our CRR annual summary report, we did find during the short-term trading and excessive desk reviews conducted that firms maintained adequate documentation in this area, including documentation to support the firm's rationale for waiving a short-term trading fee. So who we oversee ranges from simple one-person registrants that work out of their home offices to large, complex firms with several locations, thousands of employees and clients, and billions of AUM. As a result, compliance systems widely differ, and there is no one-size-fits-all compliance system. It is up to each registered firm to determine the most appropriate compliance system for its operations. Registered firms should consider the nature, size, complexity, and risk of the firm's operations when establishing a compliance system. Things to take into consideration would be the firm's registration categories, the types and amounts of products and services provided to clients, the types of securities and investment strategies used, whether the firm has individual or institutional clients, the number of locations and the jurisdictions it does business in, and whether there are any compensating controls that exist for risk areas identified. So for example, a large registered firm with diverse operations may require a large team of compliance professionals with several divisional heads of compliance reporting to a CCO dedicated entirely to a compliance role. At large complex firms, it is generally appropriate for the firm's CCO to dedicate most or all of their time to compliance, and for the firm to also have other staff employed in a compliance role. Small firms may have resource constraints that make segregation of duties difficult or impossible. In smaller firms, there may be an overlap between the compliance function and business functions. In smaller firms, the CCO may also have operational responsibilities, including trading and advising. These challenges make ensuring good documentation practices and controls especially important for small firms in order to demonstrate compliance. In these cases, it is particularly important to have policies and procedures in place to prevent or adequately address any conflicts of interest that may arise in the performance of compliance responsibilities. In addition, many firms also engage external legal counsel or compliance consultants to provide advice on compliance, including making recommendations to improve the firm's compliance system. Firms and their compliance systems widely differ. Our assessment of the adequacy of a firm's compliance system takes into account the structure, size, and complexity of the firm being reviewed. We will now discuss how CRR staff performs this assessment. So as part of our compliance field reviews, we review and assess the firm's compliance system. This slide lists examples of the steps we may perform when assessing the adequacy of a firm's compliance system. This may include reviewing the firm's supervisory structure, risk management and internal controls, testing the firm's internal controls, such as their automated compliance system, reviewing whether sufficient resources are dedicated to compliance, reviewing the firm's policies and procedures manual and code of ethics, assessing and testing the firm's procedures to monitor and assess compliance. It may include testing a sample of transactions such as KYC and suitability, pricing, net asset value, trading. And as part of this assessment, we will also assess whether the UDP and CCO are fulfilling their regulatory responsibilities, which I will discuss on the next slide. So as mentioned, when we assess the overall adequacy of a firm's compliance system, we also assess whether the UDP and CCO are fulfilling their responsibilities. This is particularly important as we have often seen that inadequate compliance systems may stem from a CCO or UDP not adequately performing his or her responsibilities. This slide lists examples of steps that we may perform when assessing whether the UDP and CCO have fulfilled their responsibilities. So we will interview the UDP and CCO and other staff. This assists us in understanding the respective individual's proficiency and compliance-related duties. We will also want to understand how the UDP supervises the activities of the firm, what the UDP has done to promote a culture of compliance. We will assess whether the CCO has given adequate attention to the compliance function, and we'll want to gain an understanding of how the CCO monitors and assesses compliance by the firm and the individuals acting on its behalf with securities law. We will review the delegation of compliance duties and assess the lines of communication between the CCO and UDP. We want there to be frequent communication between the CCO and UDP, and we will assess whether the UDP gives the appropriate attention to the compliance area and treats non-compliance seriously. We will also review the CCO's report to the board and assess how non-compliance was identified, escalated, and addressed. So here are some examples of what we've observed at firms with inadequate compliance systems. So usually it is a combination of these examples that inform our decision to conclude that a firm has poor compliance or that the CCO and UDP are not fulfilling their regulatory responsibilities. But even one of these examples could be determinative depending on the circumstances surrounding the finding. So some examples of factors that may indicate an inadequate compliance system include a large number of securities law deficiencies found at the firm, or a small number but serious deficiencies that are found at the firm. If the firm has repeat deficiencies, and this raises concerns as deficiencies that were previously identified should have been corrected by the firm. If there are no internal controls or policies for significant areas of operations. If there's no monitoring for compliance on key areas, such as no review of employee personal trades. Other areas would be where a CCO lacks awareness of the business, its key risks, and applicable securities law, or if the CCO has limited involvement in the compliance function or gives it inadequate attention. If the CCO has not prepared a report to the board or does not prepare a fulsome report. If written policies and procedures are not being followed or enforced. And lastly, if there are poor books and records, such as missing or incomplete client files or agreements. So this brings us to part 3 of our presentation. In order to help firms comply with securities law, registered firms are encouraged to meet or exceed industry best practices. The compliance team makes recommendations for best practices through a variety of different resources. So this slide has some resources to assist firms in navigating an OSC compliance review, including the link to our main webpage dedicated to dealers, advisors, and investment fund managers. This slide provides you with links to a sample books and records request for the firms that are registered as IFMs, PMs, or EMDs. Ty spoke briefly about our branch's annual summary report. We do encourage registrants to use this summary report to learn more about education and outreach activities, outcomes from regulatory oversight activities, including deficiencies noted through our compliance reviews, and the impact of any upcoming initiatives. As we indicated earlier, the report can be used by registrants as a self-assessment tool to strengthen compliance and make changes to enhance a firm's system of compliance, internal controls, and supervision. There is a link to access directors' decisions relating to opportunities to be heard by year or by topic resulting from staff's recommendation for further regulatory action. The guidance on this slide outlines our process and criteria that we look at when approving or accepting a compliance consultant imposed as a result of a regulatory decision. Although the staff notice is to provide guidance to registered firms when they are required to engage a compliance consultant as part of a regulatory decision, the discussion in this staff notice may be helpful to any registered firm looking to hire a compliance consultant. On this link, we include the topical guide for registrants, which provides registrants with easy centralized access to compliance and registration guidance materials organized by topic. As all of you are aware, we continue to interact with our stakeholders through our registrant outreach program. The calendar of events provides a list of upcoming and historical free educational seminars. In closing, the best way to prepare for an OSC compliance review is by having an effective compliance system that is appropriate to the registered firm's business. An effective compliance system enables registrants to understand their regulatory obligations, to assess if they are complying with them, and to take corrective action when necessary. So this concludes our presentation. Thank you for attending, and we will now open the floor to any questions that you may have.